Florida airspace is now a legal topic, not just an operational topic. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with what I believe is one of the most important legal developments for large turbine aircraft operating in Florida today. That is, access to the state is no longer simply a scheduling problem, it's a legal compliance problem. For years, many owners thought of Florida as easy business aviation geography. Multiple reliever airports, strong FBO infrastructure, familiar winter migration patterns, deep charter and management support. That description is now incomplete. Recent reporting from the NBAA and the FAA shows that Florida airspace has become a concentrated risk environment because of recurring South Florida presidential restrictions, heavy seasonal traffic, expanding air traffic control management initiatives, proposed Class C changes at Fort Myers, and periodic space operation closures tied to Cape Canaveral. In other words, the state is still a gateway for business aviation, but it is now a gateway for more moving legal parts. The first rule people need to remember is simple and non negotiable. Section 91103 requires the pilot in command, before beginning a flight, to become familiar with all available information concerning that flight. That sounds ordinary until you apply it to large cabin or super mid sized operations headed to Florida on a high value passenger environment. At that point, NOTAM review is not clerical. It is risk allocation in real time. The second rule is even more memorable. Under Section 91-141, it prohibits operations contrary to presidential and other public figure flight restrictions published by NOTAM. NBAA reported in January 2025 that President Trump's second term brought the return of presidential TFRs over Palm Beach International Airport and South Florida, with new requirements for business aircraft operations. As of April 21st, 2026, the FAA's graphic TFR system was still showing active Florida security and VIP restrictions, including a new West Palm Beach TFR for April 24th through April 25th, 2026, and standing Palm Beach security NOTAM running through October 20th, 2026. That is that is why the subject is hot. The TFR issue is not hypothetical. It is live, recurring, and should be a significant operational consideration. Remember this, in Florida, legal trouble can begin before the engines start because the violation may be in the briefing, not the flying itself. This matters especially for large turbine aircraft because the operational consequences scale with aircraft complexity. A turbine trip into Palm Beach is rarely a casual hop. It may involve a principal, support staff, security, repositioning, a managed craft dispatch chain, and a narrow arrival window. When that trip is disrupted by VIP TFR, a route cap, a tunnel, or release time issue, the stress on the crew and scheduler rises. And stress is where legal mistakes become plausible. Recent NBAA reporting in 2026 describes Florida airspace as a funnel, with traffic from the north and west converging with departures from South Florida and the Caribbean. The same report explained that the FAA and industry task force work had produced capping and tunneling initiatives designed to keep traffic moving. That sounds technical, but the legal message is straightforward. The operational environment is now so managed that failing to account for system constraints can look less like bad luck and more like poor pre flight planning. There is another a Florida specific angle. The FAA announced in March 2026 that it's proposing to modify the Class C airspace over Southwest Florida, including International Airport at Fort Myers, because of the complexity and volume of traffic. Existing flight paths would not change, but the airspace in which pilots must interact with ATC would expand. That matters for turbine operators because large turbine activity tends to concentrate at airports where complexity already exists. Naples, Fort Myers, Palm Beach, Opelika, Fort Lauderdale Executive, and the Miami system. The legal significance is not that the sky changed. The legal significance is that the expected compliance burden changed and significantly increased. Add to that Florida's space operation overlay. FAA notices and current TFR postings continue to show space operation restrictions around Cape Canaveral issued under Section 91-143. Large turbine operators moving between South Florida, Central Florida, and the Northeast now need to think not only about weather and runway performance, but about federal security airspace, launch windows, and system management routing. The point is not to create alarm. The point is to reframe responsibility. The best FAA turbine operators now treat airspace compliance as a broad level operating discipline. They build presidential TFR review into dispatch, verify routing against current FAA and NBAA regional guidance, preserve proof of NOTAM and route review, and brief the principle that Wheels Up in Florida is often contingent on a federal airspace regime that may change with very short notice. And there's a second thing that should be remembered and worth noting. The aircraft may be private, but the airspace problem is public law. So when people ask for the hottest legal topic in Florida business aviation, I don't think it starts with a lawsuit. It starts with access. Because the modern Florida legal issue for large turbine aircraft is whether the operation was planned for the state that exists now, not the Florida operating environment people remember from 10 years ago. In brief, one of the hottest Florida legal topics for large turbine aircraft is the migration of airspace management into legal risk. Presidential TFRs, regional flow programs, proposed Class C expansion, and space operation closures all mean the same thing. Florida operators or Florida operations require a higher level of documented compliance discipline than many owners assume. I'd like you to take this away and remember this. In Florida, airspace has become part of the contract, part of the schedule, and part of the liability story. Airport access, FBO power, and the law of who gets to serve the jet. Now let's turn to the second hot legal topic in Florida, presently facing many: airport access and control over who gets to serve the airplane once it gets there. This is where many owners make a category error. They assume airport access is a real estate or customer service issue. In fact, for large turbine aircraft, airport access is often an administrative law issue, a grant assurance issue, and sometimes a competition issue. A foundational lesson comes from Palm Beach County versus FAA, decided by the 11th Circuit in 2022. The dispute arose out of Lantana Airport in Palm Beach County. The county had an ordinance restricting pure turbojet aircraft and cargo aircraft over 12,500 pounds. But the court described the county's enforcement position as effectively banning all jets from the airport. After Captain Errol Foreman landed a Cessna jet at Lantana, the county threatened fines and jail time. Foreman filed a Part 16 complaint. The FAA agreed with him, and the 11th Circuit denied the county's petition for review. The lesson is vivid and memorable. A local airport sponsor does not get to rewrite federal access principles just because a jet is unpopular. This case continues to matter because it frames the legal architecture for Florida airport disputes. If a public airport has accepted federal funding, grant assurance constraint how the sponsor treats aeronautical users and service providers. The rhetoric may sound local, but the law is not. That takes us to a current news driven example. In late 2025, Aviation International News and Aviation Week reported that Private Sky Aviation Realty, the longtime operator of the sole FBO at Southwest Florida International Airport in Fort Myers, sued the Lee County Port Authority over the award of a competing FBO lease to Signature Aviation. According to those reports, the dispute centers on allegations that the authority changed key terms and negotiated a more favorable lease structure without proper notice. Whether those allegations are ultimately proven is for the court, but the legal significance is immediate. One of Florida's principal business aviation airports is now the site of active litigation over who may provide large aircraft ground services and on what terms. Why is that a hot topic for large turbine operators? Because the FBO is not merely a building. It is the practical gateway to fuel, hangar space, GPU service, crew support, security access, lab and water service, catering logistics, de-icing planning if required elsewhere in the mission chain, customs coordination when applicable, and maintenance escalation. When an FBO dispute erupts, turbine owners feel it in pricing, access, congestion, and service predictability. I'd like you to remember this. Take this away. For a large turbine aircraft, the airport lease is often invisible until it becomes operationally decisive. Florida makes this more important because so much business aviation is concentrated at a handful of high demand airports. That concentration amplifies the value of leaseholds, development rights, and non exclusive use structures. It also means that disputes which sound like landlord tenant disagreements are, in reality, disputes about market entry and aircraft access. There's also a deeper legal misunderstanding here. Operators often speak as though the airport and the FBO are a single thing. They are not. The airport sponsor has its own public law obligations. The FBO has its own lease rights and limitations. The operator has its own federal regulatory duties, and the aircraft owner may have contract rights against still another party. Once service interruption occurs, people discover that the legal map is layered and not flat. This is where Florida Statutes Chapter 330 also matter. Florida regulates airports through state law, but public airport operation remains deeply intertwined with federal law, federal grant conditions, and FAA oversight. That overlap is why Florida airport disputes can quickly become hybrid controversies involving local rules, state procurement of bidding claims, federal grant assurances, and practical Part 91 and 135 consequences. A current side example shows how public law and operational reality can collide. In April 2026, a Palm Beach County pilot filed suit challenging the state law renaming Palm Beach International Airport, arguing that asynchronous charting, database, and communication changes could create confusion and cost. I'm not suggesting that lawsuit will define aviation law in Florida. I'm saying it demonstrates the present environment. Even an airport can become a legal aviation dispute where operational systems and public authority intersect. There's a practical lesson or something to consider from this. on a large turbine aircraft, do not treat airport access as solved merely because you have a destination and an FBO reservation. Ask a more sophisticated set of questions. Is the airport sponsor in active controversy? Are there lease disputes affecting service continuity? Are there local restrictions or noise procedures that interact with federal rights? Is the preferred airport politically or operationally fragile? Is there a realistic alternative that preserves passenger expectations without placing the crew into a compressed legal or logistical corner? In short, the second hot legal topic in Florida is control over access after arrival. Palm Beach County versus FAA shows that local hostilities towards jets can collide with federal law. The Fort Myers FBO litigation shows that service access at Florida's business aviation airports can become active courtroom territory. For turbine owners, that means airport selection is no longer only about runway length and proximity. It's also about the current governance of that airport. I'd like you to take this away and remember this. In Florida, the legal right to use the airport and the practical ability to use it smoothly are no longer the same thing. When Florida aircraft deals and Florida flight departments end up in court. Finally, let's discuss the third hot legal topic in Florida. And this is one that keeps returning to the public in the public record. When aircraft disputes mature into litigation, they usually become fights about paper promises and responsibility rather than about the beauty of the airplane itself. Florida is a natural forum for these cases. The state has a dense concentration of brokers, management companies, FBOs, maintenance providers, charter operators, and aircraft owning entities. When large turbine deals go sideways here, the disputes tend to expose the same recurring fault lines: title, records, inspection rights, insurance placement, agency authority, and post-delivery blame shifting. A Broward-centered cluster of cases involving Whirljet is instructive because it shows how common these themes are. In UN2JC Air 1 LLC versus Winnington, a Florida appellate court described a Learjet lease purchase arrangement in which the buyer alleged concealed defects, substantial repair expense, and the aircraft being taken from the repair center without notice. The opinion noted that the resulting conflict generated 15 years of litigation. That is not an extraordinary sentence, but it's also a warning. In turbine deals, a bad handoff can create litigation life longer than the useful life of the aircraft. The Whirljet line continued in Zuma Seguros, a Southern District of Florida matter, where the public record reflects allegations involving lack of ownership, access to maintenance and logbooks, and claims that the buyer had been denied the records necessary to evaluate the aircraft. Whether any given allegation was proven is less important here than the pattern. In large turbine aircraft transactions, records access is not a side issue. It is the issue that often determines whether a dispute becomes a lawsuit. The same practical theme appears again in the Don Renee Holding case in Broward, even where the appellate decision addresses injunction and fee questions rather than the entire merits picture. The procedural history itself is useful for an audience. Once a Florida aircraft dispute enters emergency injunction territory, the case is usually no longer about convenience. It's about attempted control over an aircraft, a deal, or a business relationship that has already fractured. And here's something I want you to remember. In Florida turbine litigation, the first argument is often about the aircraft, but the lasting argument is about the documents. This brings us to a more current and dramatic example from the news. In September 2025, Hoppajet Worldwide Jet Charter and related plaintiffs filed a products liability action in the Southern District of Florida against GE. Bombardier, Learjet, Duncan Aviation, and other defendants arising out of the February 2024 Challenger 604 crash near Naples. Public reporting and the docket reflect allegations concerning corrosion, engine-related defects, and maintenance and service provider responsibility. Again, I'm not endorsing allegations. I'm highlighting why the case matters. It shows how quickly a large turbine event in Florida can expand into multi-party litigation involving the operator, OEMs, engine manufacturers, and maintenance organizations. And this is a hot topic because Florida owners often underestimate how litigation broadens after a serious event. The claim is rarely confined to one maintenance act or one failed component. The lawsuit becomes an ecosystem case. Who owned the aircraft? Who controlled maintenance decisions? Which records existed? What service information was received? What was deferred? What was disclosed at sale? Who had authority to approve the aircraft for return to service? Each of those questions can move liability and coverage. And here's a deeper point. There are no freak events. They arise because Florida is one of the nation's busiest large aircraft transaction and operations markets. The density of activity means the same dispute patterns recur with unusual visibility. So, what should owners, principals, and flight departments do if they want to stay out of this litigation cycle? First, do not close on a large turbine aircraft in Florida with loose assumptions about who owns what. Confirm title chain, FAA filings, lien releases, and beneficial ownership authority with the same discipline a lender would demand. Second, treat maintenance records access as a closing condition, not a courtesy. Full maintenance records, program status, damage history, log continuity, and digital backups should be specified, timed, and verified. Third, align the paper with the operation. If the airplane will be managed, chartered, or made available to affiliate users, the contracts must reflect the actual operating structure. Florida disputes grow when documents tell one story and daily practice tells another. Fourth, plan for the forum before there is a fight. Governing law, venue, escrow instructions, indemnity structure, expert selection provisions, insurance notice obligations, and preservation of electronically stored records all matter more on a large turbine aircraft than many parties admit at closing. And fifth, remember that newsworthiness usually follows concentration. The reason these Florida topics are of interest is not merely that reporters found them. It is that Florida sits at the intersection of money, mobility, seasonality, and density in business aviation. In short, this third hot legal topic in Florida is the reoccurrence of large turbine litigation over access, records, title, and post-event responsibility. The public record from Broward and the Southern District of Florida show that these disputes are not necessarily exotic. They are recurring, expensive, and highly instructive. I'd like you to take this away. In Florida, large turbine cases that reach courts usually begin months earlier when someone accepted ambiguity in place of proof. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. Questions are welcome. please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you with your aviation-related legal needs, and we look forward to answering your questions with precision.